Hey, everybody, and welcome back to the Legal Weekly Wine, where we talk about the week's hottest legal topics. This last week was week number 6 of the Donald Trump trial in New York. We are going to be reviewing that. We are the Law Unscripted, which is hosting the Legal Weekly Wine. We have a website, check it out. We have law review material, bar review material, and this podcast. So check us out on there, like and subscribe while you're at it. I'm Virginia Tarani. I am the CEO of the Law Unscripted, as well as the owner and attorney of Tarani Law, LLC, because you never need a lawyer till you do. I am joined for the weekly wine by 2 colleagues. My first is Chelsea Rogers, who is also an attorney with Tarani Law and is also with basically our main highlight between you and me of the Law Unscripted. Welcome, Chelsea.
Hey, glad to be here. We got a lot to talk about this week.
We really do. So this is a great legal analysis, especially for a week where people thought meh. So we're going to talk about the meh and what it means and what we might be able to do with it. So in addition to the 2 of us as the legal analysis part of it, we've got a political scientist with us who is a Constitution and constitutional law scholar. He's the dean of the Honors College at Middle Tennessee State University. Welcome, Dr. Vile.
Good to be here.
All right, so was your analysis this week, is it just me, you 2, or was it meh?
Well,
It was meh. I mean, we had some bets going for it, so I feel like that was exciting for us, but
okay, you're confessing to it. Okay, you want to review
starting out
what that was?
yeah, I lost, which is really sad for me. I really thought that Donald Trump would testify. I didn't think his attorneys would be able to prevent him from doing so, but I was wrong, and hey, I'll admit it.
Yeah, that makes 2 of us. So the vote was 2-1. You and me, we voted truly that Trump was going to testify. I had the same opinion. I thought he's too egotistical. He has to have the final say. And Dr. Vile was the only correct one. So
Okay,
you
but
won the bet.
well, but let's modify it a little
Oh.
because 2 witnesses were called.
Mm-hmm.
And it's hard to believe. And the only witness really of consequence, I mean, one was a paralegal, just sort of testifying to some documents, but Costello, who was presumably testifying on behalf of the defense, was almost surely called at Trump's insistence.
Oh,
Because
you think so?
well, it almost has to be, because if you had previewed this guy, you would never, as an attorney, have let him get on unless your client insisted, right?
Yeah.
10 minutes into the testimony, he had insulted the judge. The judge cleared the room, told him not to roll his eyes, tell him not to try to stare him down.
Right, are you staring me down?
Yeah, and what's bizarre about it is this is an attorney who would have really little excuse for not knowing what proper decorum in a court would be.
Exactly.
But it was, we talked about this before. What would have been the better strategy? We had talked about just saying, Your Honor, after listening to testimony of the prosecution, we really don't think they've established their case. We're comfortable not bringing anyone to the stand.
Yeah. We
instead,
don't need to put on a defense. We rest.
Right, which is dicey.
But
what they did is probably even dicier. I mean, basically, one main witness who antagonizes the judge seems even less credible, if that's possible, than Michael Cohen, and makes you wonder, if Trump surrounded himself with people like Cohen and Costello, what kind of enterprise do we have going on here? So, and again, easy to say in retrospect, but they did have the right to sit down with Costello before the
absolutely
testimony. And when they saw it, if they had any indication that this is what was going to happen, they should have again told Trump, hey, somebody else is going to have to do the direct, because I'm not going to do it.
Absolutely. I think I would have said, look, this guy's terrible. I don't think he's helping you. I mean, he's better than you. It's if you have to pick one, I'd rather this guy testify than you testify, but neither should.
You know what I find fascinating about this trial? And somebody's going to have some explaining to do.
Huh?
Trump is constantly saying the judge is biased. And by the way, one of the reasons he says that he's biased is that he's from the country of Colombia. So it's clearly a racial,
An immigrant issue.
right, you know, which I mean has nothing to do with bias at all.
Mhm.
But you know, he's saying that he would say that the jury is corrupt, except he's not permitted to do that. He
Right.
slams the process. He says it's all whatever. How's he going to explain it if the jury exonerates him?
I think it's okay. Hold that question because I definitely want to answer it. I have two answers to it, but I
Okay.
need a drink.
Okay.
So before I answer, let's take a drink. This is the weekly wine. It's, you know, happy hour type of thing. Let's grab our glass of wine. Chelsea, I'm going to start with you. What are you drinking today?
I'm back at it with my favorite boxed wine. I have some Franzia. It's the pink one, the new pink one. It's like a sunset or something. I don't know. It tastes like Moscato, but it's pink. So I love it.
Nice. Okay. A good old standby. Dr. Vile, have you
I'm
got the
back to the
campuses?
university monopoly Pepsi.
Pepsi. Excellent. Excellent. I think I would gain more weight on your campus because I like Diet Coke, but I like Pepsi. So I would just be drinking more sugar because I can't stand Diet Pepsi. Or well, I do like Dr. Pepper, but anyway, okay, so I ran out of wine, shockingly. I know it's terrible. Of all the people, I ran out of wine today. So I have to go back to the store. But I was like, okay, I at least have to have some alcohol. What else do I have in my store, right? In my own stock room sort of thing. So I pulled out the funkiest thing that I have in my home. And it is a
Ooh.
sour ale. I love sour ales,
Okay.
especially in the summer. Oh my goodness, I've had some great ones. This one is funky and it tastes good enough that I'm drinking them, but it is wild. It is a fruit tart, cranberry, cherry, cinnamon.
Oh.
It's a beautiful can. And it is from Mully's Brewery. So it's, again, it's not wine, but it's the closest thing and the funkiest thing I have. And there is a kick to it. My husband can't stand it. I have to take it in sips. I'm trying to figure out if it would mix well with something. That cranberry in there is a little wild. Cherry and cinnamon, okay, but they threw in the cranberry and it's eh. So it's a meh day for the meh trial with a meh sour ale. Cheers to everybody. Okay, Dr. Vile, let me answer your question. So I think Trump is setting, so the question basically is, what is Trump going to do since he slammed the process, called the justice system and the people in the justice system corrupt, pro-Biden, brought only by Biden? What's he going to do if he's exonerated? I think he has a plan for if he wins or loses. And I think he's going to make a martyr out of himself either way. Yep. I think his strategy, okay, do you see where I'm headed?
I absolutely agree. I think what he's going to do, this is his out, because he was banned from talking about the jury, right? So if he is acquitted, he's going to say the jury persevered through this bias system. And if he loses, he's going to say that the jury gave in to the bias system. Like, that's it. He's going to blame it on the 12 in the box. Either way.
I agree. You're headed exactly where I was.
So yeah. May I make a comment here?
Yes.
Since we're recording on a Sunday.
We are, yes.
Do we remember the story of Samson's demise?
I do. I don't know that everyone will. It's a great Old Testament biblical story.
Okay, so he's the thorn in the side of the Philistines because of a woman named Delilah. He is betrayed. His eyes are gouged out. And they're having a huge feast to, is it Dagon or Baal? I'm not sure. Dagon, I believe. Anyway, whatever their idol is. And they're in this huge room with big columns. and he has a slave boy who's tending to him because he's blind, go to the pillars, and he brings them together, and 10,000 people or so are killed as the building comes down on him. And the problem here is, if we want to go now to the analogy, that's sort of what Trump is doing. If he wins or loses, he's going to bring the whole system down.
Yes.
The problem is, it's our system. It's not the Philistine system. It's not the Russian system.
Mhm.
He is denigrating the entire criminal justice system.
Right.
And there are some of us who are still naive enough, I guess, to believe that no matter how biased a prosecutor is, or what political issues there are, that one of the defenses, particularly of ordinary citizens, and I'm not sure I think Trump is an ordinary citizen, but one of the primary defenses of an ordinary citizen is a jury trial.
Right.
You know,
A
12
jury of their
12
peers.
people tried and true from your own, neighborhood. And I think that is we don't realize how really unusual that system is, even in England, which is, where we borrowed it from. Very unusual, as I understand it, to have a jury trial anymore. But it's one of those defenses, against corrupt or overzealous prosecutions.
Right.
And I'm less worried. I mean, I do not have a strong opinion as to how this case is going to come out. Part of it is I haven't been sitting there for 6 weeks. And so, everything we're getting sort of is hearsay. I mean, you can read the transcripts, but it's not the same as seeing the witnesses. I don't know how it's coming out, but I have a fundamental belief that people don't sit for 6 weeks outside their home listening to what, through much of it, was fairly mundane and boring testimony.
Yeah.
Until we got to
20
Stormy Daniels and
witnesses,
Michael
yeah.
Cohen, it
Two
was
for
a
defense.
snoozer. I don't believe people give up that much of their time simply to get somebody, or even to, now, there could be a hung jury, that then there may be a hidden, I'm for Trump all the way, or I'm against Trump all the way, that could skew it. But I just think we need to renew some of our faith in the, this comes out of the Bill of Rights. It's a fundamental protection that we have. And I think it's been terribly effective in our history.
Yeah, I think so too. I mean, what better system is there?
Yeah.
Yes, we have. Is the system broken in some ways? Absolutely, there are cracks. There are pieces where it doesn't work. There were pieces. How many decades ago we're dealing with the civil rights movement, and there were, and even, goodness, Brown versus Board of Education overturned Plessy versus Ferguson. And, we've had issues in our system, but the system continues.
Well,
And
and
the
a lot
system, for
of
the
the
most part,
issues
works
did
out.
not deal so much with the jury system as they dealt with the lynch mob, or
Exactly.
bypassing protections for the jury.
Exactly. So it was more important to make sure that the legal system worked, and we got people into the legal system, because it is ultimately based on a prosecution which has a check on it by the defense. And
Multiple
I used to
checks.
absolutely. I used to do criminal defense. I still do a little bit here and there. But, I got asked even by my grandmother, how can you represent those who are guilty? And I had two answers. One is, I said, they're not all guilty. And the second that I said is, even if they are guilty, the system is so important that somebody has to be there to put a check on the prosecution. And as a prosecutor, someone needs to be there for the victims. Someone needs to be there following justice. And you hope that, the better they both are, the higher they both go. The worst one is you go down to them. You meet them at the bottom rather than meeting them at the top, if both are good. And justice technically should occur.
And if it, even beyond the jury system, you have an appeal system.
Yes.
I mean, it is possible that Trump could be found guilty and later decided that, the judge was too aggressive, or Witness should not have been able to testify about, the sexual or alleged sexual encounter with Stormy
Absolutely.
Daniels and so forth and so on. And that, that leads to the question that I think people might be interested in is there's been a lot of discussion toward the end of the week or whenever it stopped this last week over jury instructions.
Mhm.
And apparently there was close to a full day or so where each side presented to the judge what they thought the judge should say. And Virginia, probably you had the most experience of any of us. What do you expect? I mean, tell us how important these are, and does a judge usually compromise between the two, or are there usually legal guidelines that he simply follows, or what exactly is the situation?
Most are fairly easy and mundane. It's more of a checklist, but both, like you said, both parties come up with, these are the jury instructions I want the jury to hear. The judge reads them out either before or after the closing arguments, and it's instructions to the jury. One of the biggest ones that I know both sides are going to put forward or already have is the one of the defendant has a right not to testify. Right. You cannot make a decision based on whether he did or did not testify. You cannot think of him as guilty just for the fact that he didn't testify. So some kind of variation of that rule.
There's a Fifth Amendment right. So
yes, exactly. But they're phrased in certain ways. So both sides pick and choose which ones they want. They put together a full packet. They give the judge a packet. They give the other side a packet. Both of them mirror each other in a lot of ways. In every state, there is generally a set of jury instructions, normal jury instructions. You pull from that, they're numbered, you pull from that, and you do all of the normal jury instructions. So you talk about credibility. Then there are a few that they throw in that aren't necessarily the normal jury instructions, and that's what they're fighting on. They're not going to be fighting on the normal jury instructions, which are probably 20 to 50. They're going to be fighting on the ones they put forward that have alternate theories of how it's presented, or they're based on case law rather than the model jury instructions. That's what they're going to be fighting over. And the judge ultimately makes a decision. Do we put that one in or do we take it out? And that's where appeals are made.
Right.
Is if the judge makes the wrong decision as to include or not include a proposed jury instructions. And both sides, it's almost like an objection. One puts it forward, the other side objects and says, this is why it shouldn't be in. There's oral arguments on both. Once in a while, the judge will make them do it in writing.
So talk a minute about directed verdicts, because that's also been in the news.
Yes.
And viewers will remember that last week we said, don't be surprised, if at the end of the prosecution case, the defense says, Your Honor, there's nothing to go forward here. That's exactly what happened. It was reported. In fairness to the reporters, they sort of got it right. Most of them said this is fairly typical. Instead of locally, when this happens, everybody says, oh, the case is about to be thrown out. And of course, it's just a routine kind of motion. But is there a chance at this point? My assumption is, a judge does in some cases, right, have the authority to say there's no need for the jurors to meet here. The fundamental basic level of proof was not offered that a conviction could be rendered here. I'm going to dismiss the jury and exonerate the client.
Absolutely.
That could happen, but is very unlikely to happen. Is that right?
I would be shocked.
Okay.
It's one of those things where I would have to eat my hat, right? I bet on something so much that I would eat my hat if it happened, because it's already been overruled. So the prosecution goes, the defense, in order to present a defense and be a good standard attorney, you could possibly be disbarred for not making a motion for a directed verdict after a prosecution case, because that's how you preserve your appeals. Okay. You say, we made these objections and we heard only this testimony, but we didn't hear X, Y, and Z. So the prosecution didn't prove their case. It's not beyond a reasonable doubt. So what you're saying is they've failed to present a case, so much so that it can't even withstand whatever it is for the state.
Sort of prima
Yeah.
facie,
Compelling
right?
it.
For
Well, it's
viewers
not
who know that.
necessarily prima facie. It's usually
It's the one that's like no reasonable jury could convict this person.
Okay.
And so as a matter
Yes.
of law, we're not even going to send it to them. I only know because we just did a whole bunch of research for this for one of the
It's
like
true.
that phrase was in like every single one of the cases that I had to look up for Virginia. And it was like no reasonable jury could convict, essentially.
Right. There's no set of facts that they could use to match with the law that would
Law
provide a
says.
conviction. So the judge has already said, yeah, whatever. Essentially, he said, no, I disagree. And now they have to, again, for appeal, they have to renew their objection. They have to renew their request for a directed verdict. If they didn't renew their request for a directed verdict, then they lose their appeal. Because the judge, the appellate court will say, but you didn't preserve your objections. You didn't preserve your right.
And one of the problems the defense has in making an appeal is it sounds like one of the things that they might try to appeal on is that testimony was let in that they think is irrelevant, particularly dealing with sexual affairs.
Oh, Stormy
But
Daniels.
the two problems there are, one is that Trump denied it, and so that sort of opened the door. But the other, as I understand it, is his own attorneys did not make those objections during that testimony. So unless he wants to plead incompetent counsel, which at the rates that he would have to pay would probably be pretty hard to do, probably that avenue is not particularly open. But what I can tell from the commentators is I think many of them, I mean, I have seen some who say, yes, we think there's plenty of, people sort of biased anti-Trump tend to say, yeah, I think they've proven. And then the others are saying, well, they prove certain things, but the link between that and campaign finance is so tenuous that I'm not sure the jury will get it. So,
or we're not certain that Trump directed the signing of the checks.
That's right. That's right.
Or even if we think that he did it, I don't know if the prosecution has proved it, which is where
Right.
I feel like I'm finding myself. I absolutely think it played out as they have presented. I don't know that they've been able to really conclusively, in my mind, at least from what I've seen, present that. It may have happened, but you also have to prove it. And I don't know if they've actually proved it.
Yeah, and that's what the defense is going to claim with this second directed verdict. We renew our request for directed verdict, but they've only, like you were saying at the beginning, they only called 2 witnesses.
Right.
And one of them harangued the judge. The other one was so inconsequential, I don't even remember her name.
Paralegal, yeah.
Yeah, so
that was just to get those documents in. I feel like it wasn't really even about her testimony.
I agree. So they would have had to present some kind of extra evidence that was so incredible to overrule all of the prosecution's witnesses. And the judge would say, look, nothing changed between the last time you issued your first request for directed verdict and today. So I'm going to deny it again. But again, it's more of the possibility for appellate arguments.
So let me ask another question. If we're going to bet again, how long do we think closing arguments? Now, let's talk a little bit about that. In a closing argument, each side is going to try to highlight the evidence and the witnesses that they call that they think sustain their case or holes in the other case. But I believe I'm right on this. One thing you really have to watch in a closing is that you don't claim something that didn't happen. It's sort of like the openings. If your opening says we're going to call Donald Trump, which I don't think it did.
It didn't.
But if you had said that and you didn't call him, then no matter what instructions a judge gives, it's going to be hard to say, well, they said they're going to call him and they didn't. He must be trying to hide something.
Well, let me exactly use that and then ask Chelsea a question with it.
Okay.
Dr. Vile, you're saying, I agree that I don't think they said we're going to call Donald Trump and then he didn't appear. So the jury's going to say, well, the defense itself is lying. But here's what they did say. They did say Donald Trump did not have sex with Stormy Daniels. Now, Donald Trump did not testify. Chelsea, what do you think? Is there any proof that the defense put forward to show their claim from the opening statement that he didn't have an affair with her?
No, like not at all. And I also think it's just a weird, in the context of what he's actually been charged with, right?
Yeah.
I find it like a strange thing that they incorporate it, because if I was the defense, I would want to take all of the attention off of the scandalous parts and really just make it a boring trial about boring business documents. And they didn't do that. They didn't try to do that at all, which is like, maybe I'm stupid, but like it's really hard for me to wrap my brain around why that choice was made, like strategically, because I think that saying again, like saying that in the opening statement is crazy, because the only proof you can offer against that is like a he said, she said. Well, if he's not getting up on stand, all you have is her saying it, and there's nobody else. There's no other evidence except the two people who were in the room. So it seems like just a weird choice with me, to
Well,
me, all around.
there's no other testimonial evidence.
Well, true.
No.
I don't. Yeah,
But-
I don't know how to prove
But
that
the fact that
To prove a
if you
negative?
believe that he paid 100, to go back to
Yeah.
the Romney statement, you don't usually pay $130,000 to someone not to have sex with you.
Yeah.
Right. Right.
Agreed. And so I think instead of openly saying we're going to call Trump and then they didn't, I think they suggested they would and then they didn't. And as a prosecutor, you cannot say in the closing, you can't say, well, Donald Trump didn't testify. He must be. You cannot even reference
Right.
the fact that he didn't testify as a defendant. But what you can say, and what I would say as a prosecutor, is they lied to you. They told you, Mr. So-and-so told you in the opening statement that Trump did not sleep with Stormy Daniels.
Right.
The only evidence we have is that he did. There's no evidence to counter this. So you're not saying Trump didn't testify, but you are saying legitimately there's
Right.
no evidence to counter this. So you're basically calling them liars. And, you know, they're already, this whole trial is about liars, right? So now you're making the defense itself a liar. And I would absolutely nail that and go home with it is, you know, not only did they not show he didn't have an affair, let's show how much it seems that he did, that we've proved that he did, but we didn't have to prove an affair. It's shown here, but that's not what's at issue
Right.
here. The other mistake that I think that they made, and I want to make sure, I want to see if I'm wrong. So one of you, please pipe up if I'm mistaken. I don't think there was any evidence produced about was it the night guard or whoever it was of the hotel who had tried to basically
The
bribe
doorman.
Trump?
Yeah.
The doorman.
Right.
Was there any evidence presented about the doorman who had asked for payment because he was going to go forward with this story that Trump had a love child? And then of
Which
course
was a
it was
false
proven that
story,
he
by the
didn't.
way, to
Right.
be clear. I mean, there's no evidence for it.
And actually it was proven to be true.
Right.
To be false.
Right.
That it was proven to be false. So
And
that
he's
this-
actually serving in jail, right? Or had to serve
I-
a jail term for not for
don't know.
from some other shakedown or something else illegal that he had done.
Was there any evidence of this presented?
Why would you need it? I mean, why
I think that would have been the defense's best defense.
to say he's been shaken down before, and sometimes he's had, just because he paid does not mean it happened.
Yes.
But again,
exactly.
I think the problem is the person who shook him down he's not going to be on your side, right?
Well, and that's true, but I think the defense should have said, look, 3 people tried to shake him down right before the election. And this, you know,
I don't think there's evidence. Is there evidence of the Playboy Bunny in the trial or not?
No, there's not. The only
Right.
person that's in there is Stormy Daniels, but I think the defense should have put forward both the Playboy Bunny and the doorman to say, look, he's paying for all of them, true or not. Because, and now the one trick is the prosecution would say, yeah, so it doesn't come out before the election.
Right.
It's a campaign,
Right.
you know, doing it because of the campaign. But it would have been the place to say he's not paying for it because it's true. So just because she claims it, just because there was any kind of payment arrangement by anyone, doesn't mean it's true. And at this point, I would say, look, Michael Cohen did it for his own reasons. Michael Cohen did the payment. He chose to do it, not because Trump said he should.
And that's what Costello is trying to prove.
Correct.
And you know, there was, I mean, he basically does say that Cohen told him that Trump didn't know about it. But that would be the kind of thing that you would do if you were paid to pay somebody off, right? If you're trying to hide it, you're not going to tell. So it's,
like, think about it. For
Hall of
all of
Mirrors.
this, we've heard for all of these years, and not that the jury knows this, but how many times have we heard Trump say, or it's reflected that he's going to take care of you, right? You know, and it's this idea that he's going to pay the people who are loyal to him. He'll send you counsel. He'll make sure that you have attorneys to represent you if you've done something on his behalf. So to me, it's logical that this attorney would show up on Trump's behalf. He wasn't solicited by Michael Cohen. He went on behalf of Trump to say, hey, I'm going to be I'll represent you. And
the good news is you have representation. The bad news is it's going to be Robert Costello. And he's really not on your side.
Right, he's there for Trump.
Yes.
He's there to make sure you don't testify against Trump.
Right.
And don't implicate Trump. That's what he's there for.
Yeah. Right.
So anyway, and their ethics rules, Chelsea, you might be a little more closely familiar since you're more close to the bar as to what those ethics rules are regarding the offer of representation. Are you familiar with those?
A little bit, yeah. One, I think it's interesting because you have first, when does the attorney-client relationship begin? You have all of those rules, the extensive list of those. And then you have like the idea that you're not really representing your client. Like, I think it's just, I don't know how it would break down. I don't know if you went in front of a board in any state, you know, theoretically using these model professional rules instead of, you know, the state rules, what that would look like, because I guess they could kind of make the argument that he was he was a strategic decision. I think that's what the best sort of call on his end would be, was like, oh, I strategically believed this was best for my client. And you're like, well, being an idiot's not a crime, right? Like having incorrect strategy isn't the problem. And I think that's what he would end up claiming. And I don't really know how like a board would come out on it.
Yeah, and I agree. In most states, they won't let attorneys solicit clients. Now, there are certain rules, like you can send, you know, flyers through the mail.
You can chase ambulances, right?
You can't. Well, I can, you know, kind of walk by and now I can't put my card in their car, but you know, somebody else could. I can't stop them. But there are rules like I can't call a potential client unless they ask me to. They have to call me. They have to contact me. The only way I can solicit a client is if I'm going to offer pro bono services to them. So the
you can advertise.
I can advertise. I can do marketing because it's not a specific client that I'm, you know, requesting to represent. But the question is, was he actually soliciting Cohen without payment, right? Or was Trump paying for him? And if Trump was paying for him, then is that still a violation because he's not doing it pro bono? He's, you know, Cohen's not paying him, but Trump is. So I think there are a lot of ethical issues. And, you know, it's still, Dr. Weil, you mentioned at the very beginning, an attorney getting on the stand and, you know, riling the judge up is so inappropriate, not just for a regular witness, but especially for an attorney. It should be someone extremely deferential.
So we asked a question, I think, earlier that hadn't been answered, and I am curious.
Okay.
So the two of you are now on, make one of you prosecution and the other defense. How long a closing argument do you plan to make? Do you try to make it longer because longer means you have more proof? Or do you recognize that after 6 weeks, people are probably ready to move on and keep it short, what, hour or two each? You think that's sufficient, or do you think could it go on for, is this part of the instructions? I'm not sure. Will the judge say you have X amount of time, or is that just solely up to you?
He could. He could
Okay.
say, some judges actually say you have this amount of time. I
Okay.
think it would be wise in this case for the judge to say it, but if they don't, it is up to each side as to how long they want to take.
And
Chelsea,
what
do you
what
think?
would your judgment be? Was it long or short? Probably the most likely to be effective. And it might vary from one side to the other. I mean,
I always wish people would do shorter closings. I'm sorry. I'm like, I don't have really the trial experience that Virginia does, but like, I always wish people would be so much more concise in their closings on both sides. I would be happy if they both would take 30 minutes and be done. That is never going to happen in this scenario. It's not going to happen, but that would be my ideal, especially if I was on that jury. I'd be like, great, I did what I was supposed to do and paid attention and took notes for 6 weeks. I do not need you to say it all again. Do I think that's going to happen? No. I think it'll probably be, I don't know. My guess would be over an hour, under an hour and a half for the prosecution, and about at an hour for the defense would be my guess.
okay. So let's raise something else. In mock trial,
And I have a different opinion, but go ahead, Dr.
okay,
Brown.
in mock trial, you can't do objections in opening and closings. But if I remember, there were objections and opening statements, yes, on the
Yes.
part of the prosecution objected, I believe, to the opening statements of the defense. Will there be a place for objections that we could stop a closing argument or not?
Absolutely.
Okay, there can be, but
Real
fairly
attorneys and
unusual, fairly unusual.
You try not to because I'm going to try not to curse on the show. You look like a jerk, right? It doesn't necessarily look good to the jury. So you want to save your objections. But for instance, if one of the sides starts talking about evidence that was not presented,
Right.
then absolutely object. You know, Your Honor, they're talking about things that were never put into evidence. It shouldn't be talked
Okay,
about.
so we'll be real clear.
Mhm.
The prosecution each gets one bite, or the prosecution gets 2 bites, or they both get 2 bites. If the
Chelsea, I'll let you on this.
Okay, did I unmute myself?
in
I'm
other words,
struggling
okay,
over here.
you have prosecution makes the closing argument.
Mhm.
Does prosecution may answer, is that right?
I think so.
Yes.
Okay. And
Yes.
then
Okay.
if
I was
they-
like, I was panicking for
Okay.
a second. I was like, is this a trick
I'm
question?
sorry.
Sorry.
I'm trying to think of what somebody viewing this would need
Yes.
to know as a non-lawyer, and some of things are things that
Yeah.
I don't know. But
Yeah, they get a rebuttal.
Yes,
The
yes.
the
prosecution
prosecution
gets the first
does.
You always
and
get the first and last word.
Okay, so if
You
you
knew it,
had
Chelsea.
I know.
if
I was
you
just
had
panicking that I forgot.
prosecution closing, defense closing, rebuttal, and you had then a defense rebuttal to that.
No,
No.
you cannot. The prosecution gets the first and last word. So
Okay.
it's prosecution.
And it can
defense,
only go to 3.
prosecution.
That's what I'm asking. In other words,
Correct.
or 4, I guess, right?
3.
No, 3.
Three.
Okay.
Prosecution closing.
So
defense
prosecution closing, defense closing, any rebuttal on the part of prosecution.
closing. Correct.
And that would
Mhm.
not be automatic, right? You wouldn't do a rebuttal unless
Just
you thought.
because you can doesn't
Mean you should.
Right.
Yeah. So I very rarely make a rebuttal in my cases unless it's a very big case. So like the murder trials we've had, you do a
Mhm.
rebuttal. Now keep it short and sweet. They don't want to hear another closing.
Right.
They want to hear your final response.
Yeah.
But if you've made an objection that's been overruled.
Mhm.
You're the prosecution. You made an objection that's been overruled. Can you then try to introduce that in your rebuttal?
You could, but I wouldn't.
Mhm.
I wouldn't want to focus any more on it. I don't think that's good strategy. Is
But
the same
what
as
you
the
would,
defense.
the rebuttal that we would most likely expect would be if the defense makes a statement that has not been introduced into evidence, then you would expect
An objection.
an objection,
Right.
or you might just save it for rebuttal and say this was a very interesting
They've
closing
told you
argument
yet
that we
another
heard.
lie.
It's just a shame that, none
Yeah.
of it came out in trial, and,
Absolutely. That would be where I would say truly they've just lied to you again.
Yeah.
all they want to do is lie to you from the very beginning all the way to the very end. So you focus on the big ones. For me as the prosecutor, I agree with Chelsea. With all of mine, yes, there are some that are longer than others. It depends on the degree of the trial. My, damages only cases for, a personal injury case, I hardly do a closing. I do some to make sure I highlight the amounts, etc. But I rarely make a rebuttal. I don't do a very long closing. We get into a jury trial, I do a little bit more than with a judge because I presume the judge in a bench only trial knows the law, whereas a jury doesn't.
I was gonna say this is just a slight tangent, but I think that was one of the more like shocking things about like law school versus like actual practice, saying that of like because especially like federal rules of evidence, you're thinking about a full jury trial. A lot of the times you're like your mock trials are these really dramatic things. And then you see like what your average every day to day like civil trial looks like in a courtroom, especially in a couple of the smaller things I've seen Virginia do where the judges don't even let the attorneys do direct examination. The judge is just asking questions from the bench. And you're like, how did we get so far from like what I imagine a trial to be to like what the actuality of it is?
Yeah, so exactly. So in the real world, taking an idea of you don't do closing just because you can, you don't do a cross just because you can. So the prosecution in this case, I think, should have a longer closing. Honestly, I would expect 2 to 4 hours. That's what I'm expecting because they called 20 witnesses.
I was going to say the prosecution's case was so long.
Yeah.
Mm-hmm. And now I think it would be a mistake of the prosecution to go witness by witness. I think that's an absolute mistake. I think they're going to bore the jury. I think they will be penalized by the jury. I think they need to keep it concise and on point of here's the law, because this is the first time they've been able to tell the jury what the law is. They say, here's the law and here's how the evidence fits the law.
Okay, so there's been a lot of TV commentators saying they haven't proved it because they haven't shown the connection to campaign law, but you're saying they haven't had an opportunity?
Well, they haven't had an opportunity to explain to the jury how they've proven it. They've offered the factual evidence, but now is their opportunity to say, this is what we've presented and here's how it fits.
So one of the commentators I saw said they should have had an expert witness. They should have had they should have had somebody who knows campaign law, who says, yes, I've looked at the evidence. Well, this is what's happened. And your basis was that law violated? And
I don't think they could have.
Okay.
I think it's an ultimate, one of the federal rules of evidence, or which is usually mirrored by a state rule, is you can't offer a witness who goes to the ultimate issue. You can in some cases, but I think this is too far. This is an opinion regarding the state of mind of the defendant.
Okay.
And I don't think an expert can testify as to the state of mind.
Well, I wish you had been on the show that I saw this, because when I first heard it, I said, well, that sounds right. I wonder why they didn't do it. I bet there's a reason. Can we talk a little bit?
They can't, let me finish 2 points. Yeah. Like insanity. If a defendant presents an insanity defense, there cannot be an expert who says whether he was sane or not.
Right.
And I think that's the same thing here, is I think that type of witness would be offered here to say whether he intentionally violated campaign finance law or not. So I think it's too close to that type of an expert.
And of course, if one side had presented a witness, the other would almost surely have found someone that would testify on the other side.
Absolutely.
So it might have been that could also be a reason. If you're just going to have dueling experts, it's going to muddy it up more than it's going to clarify it.
Yeah. Well, let me make one final statement on that. And then Dr. Val, I want to shift back to you.
Yes.
You asked about the defense, like whether it would be different than the prosecution for how long they would do in closing. I think the defense's best option in this case would be a shorter closing.
Didn't prove anything. Burdens on them. Don't forget that.
Yeah, much ado about nothing. Much ado about nothing.
Yes, and that honestly would be a great theme. That's a perfect theme for the defense. Much ado about nothing. Great job, Chelsea. And that's what I would do. Is the less, and that's where I think they failed with Cohen. The
Yes.
less you show, the less you do on it, the more, less important he is.
Yeah.
So I think they emphasized his importance by crossing him too long.
Okay.
So if
The
the
defense did, you
prosecution, yes, agreed.
Yes.
If the prosecution gives a 2-hour closing, defense should give 45 minutes. If the prosecution does 4 hours, the defense should do an hour and a half. But I think, and I project, here's one opinion I will make, one guess that I will make, is I think the defense in this case will make as long of a closing argument as the prosecution, if not longer. That's my, because they can't help them. They didn't help
And-
themselves with
Yeah.
Cohen.
And they want to please their client.
Yeah.
Who's going to
Yeah.
say, you know, I'm paying you just as much as they,
Right,
as
I'll
they're
argue
making.
longer. But just
Yeah.
because you're speaking longer doesn't mean what you're
Right.
saying is better.
Right.
Okay,
You
go ahead,
rarely
Dr. Bob.
convert anyone after 20 minutes, I have been told.
That's what I'm saying. I
already
wish everyone would
decided.
shut up. Like, talk for 30 minutes and be done. And if you can't summarize your case in 30 minutes, maybe you're not as clear as you think you are.
Okay.
I agree. And that goes to truly, it may not even be 20 minutes in that makes a difference. I believe before you even reach closing arguments, the jury's already decided
Yep.
one way or the other. So
I
I think
went-
they're going to get mad the longer you talk.
I absolutely
That's my
agree.
So
Okay,
can
Dr.
we talk a
Bob.
little bit about judicial ethics, something other than Trump? Because, you know, admit it or not, you know, there is going to be a time,
Mhm.
probably within the next 5 years, that there will no longer be an ongoing Trump trial of one kind or
Oh,
another.
thank God.
And we're going to have to think of something else to talk about.
Well, we found plenty to talk about
We do.
before.
So can I tell you about an embarrassing experience I had this week?
Yes, please.
It's a shame. So how many times do you get called by the New York Times?
I've never had a call. from
Well,
them.
I have had one or two before, and I actually got quoted on a 4th of July a couple years ago
Nice.
about something. But I got a call this week about the meaning of flying a flag upside down.
Oh.
And I thought, oh, great. Just, you know, my encyclopedia has just come out in paperback
About the American flag.
about the U.S. flag. That's right. It's a hardback was several years ago, and they decided it was selling well enough to put it in paperback. And so I turn and I look for upside down flags, and there's nothing there.
Oh.
And so he quotes every scholar in the country except for me. And even though I did follow up with like 4 or 5, you know, well, now that I've gotten my bearing, this. So the reason this came up, as some of you know, there is a news story that Justice Samuel Alito, shortly after or about the time of the Capitol Hill ruckus, storming the
January
Capitol,
6th.
January
Mhm.
6th, that his home, outside his home, there was an upside down flag. And it is, for those who want to know it, and by the way, I do have, since I got embarrassed by not getting quoted in the New York Times, I subsequently sent an article into our First Amendment online encyclopedia, which anybody can find for free, on upside down flag. And I did know this when he called, that it was a sign of distress. Most early flags were flown at sea. You know, we see flags all over the United States, but you really don't need to see a flag in front of a car dealership to know that you're in the United States of America, you know,
Right.
unless you're just right on the border or something like that. But at sea, you have no way really of knowing what a ship is, particularly in the early years for radio and whatever, without a flag flying.
Oh, interesting.
And if a flag was taking on water, or there was a plague aboard, or they ran out of food, they would turn a flag upside down as a sign of distress. So when
So
word
it
got
wasn't
out,
like a white flag. It was more of an upside down flag.
yeah, it was an upside down flag, and it could be any nationality. And I think that's one of the things that threw me when he called me. It's like, well, it's not unique really to the U.S. flag, but increasingly we did find some cases. There's one at least 50 years ago where it was used as like a protest against the Vietnam War. When John Kerry ran for president, he was pictured with flag upside down, expressing his concern that the country was headed in the wrong direction. Got a lot of criticism for it. So Alito's defense is a very fascinating one because it cuts ideologically, it cuts a different way. You know, we associate Alito with sort of the right wing on the court, but he says, my wife did it. And he says his wife did it. She was the one who did the flag because apparently one of the neighbors had put up a fairly vulgar sign against Donald Trump and something else. And so it was a neighborhood dispute. And she just wanted the world to know that she was in distress or her community was in distress. And it's hard to know what to do with that.
But isn't that what Justice Thomas has been saying? Is this is my wife and not me?
Well, we can get to that in a minute.
Right?
Right.
All else fails, blame the wife.
Well, and that's what some people say. But on the other hand, there is something to be said for the fact that you cannot necessarily, now, of course, I don't know whether Alito is telling the truth. I have no reason to believe he isn't. But, you know, a wife could have a very different opinion from her husband. And again, this does go into Thomas because in Justice Clarence Thomas's case, his wife actually, as I understand it, attended Trump's speech on January 6th. Now, she did not march to the Capitol, but she's also on the record. I think we have a tape recording of her or transcript of her talking to Mark Meadows and saying, you know, we really got to fight this thing. Trump is a legitimate winner of the election. And it does
She's
call into
very
question.
much viewed as a Trump supporter.
That's
And
right.
He's saying that's her, not me.
Well, I don't know if he's saying it's not me, but he's saying my opinion is not necessarily, you know, my
It's
wife
not the
has the
same
right
as
to,
my
I mean, a wife does have a right, as a husband does, to their own opinion. But now it's become a little more complicated, as maybe you know. So before this had blown over, we get another picture from Alito's house, his beach house. And I've had to check with the wife to make sure we don't have any flags outside our beach house. We'd first have to get a beach house.
What beach?
Yeah. But outside the beach house, apparently, now not at the same time, but they had an appeal to heaven flag, which is a white flag with a pine tree on it. And Virginia, I'm going to test your knowledge. You're not going to like this. Maybe you will. Maybe you'll make Dr. McDaniel proud.
Sorry,
Who
Dr.
wrote,
McDaniel.
what philosopher came up, to my knowledge, is the first to use the notion of an appeal to heaven? And what did it mean? If you don't, that's probably
I don't
It's John
actually
Locke.
know.
John Locke said, you know, when you have a civil society and you have a major dispute, the majority wins. But if you think it's so aggrieved, then you have the right to make an appeal to heaven, which basically means you have a right to revolution. Take it to the street. You know, this is a right that Mr. Jefferson enunciated in the Declaration of Independence. He didn't call it an appeal to heaven, but, you know, if someone acts in a tyrannical fashion and they don't heed your pleas and there's no legal mechanism, then you appeal to God, you know, hoping that that if you're on the right side, he will give you support. And what I did not know when I first read this, I'm actually now reading a book on it. Surprise, surprise. For some reason, I guess because of the words, the appeal to heaven, this is being used by a lot of conservative it's being used by people who believe that America has a special divine destiny. And it is used for some people to indicate that they think we ought to get back to a time where we acknowledge God as our founder, et cetera, et cetera. And so it turns out Speaker Johnson has an appeal to heaven flag outside of his office in D.C. And the person who's led this movement sort of rediscovered this flag, apparently goes and gives them to prominent politicians in the hope that they will put him out. But what's fascinating, and I don't know if we've talked about this before or not, but over the last 2 or 3 years, at least 3 justices, most prominently Thomas and Alito, have been associated with accepting what appear to be very lavish gifts. In one case, a loan, maybe a gift of 260 some thousand to buy an RV. In another, one is a vacation to Indonesia, which apparently involved a yacht and plane flights and all kinds of
Which could be
amenities.
construed as bribes.
Well, yeah, not so much quid pro quo as, we want to get on your good side. And of course, this is muddied because people do sometimes, friends sometimes take vacations together. And if one is more richer than the other, they might very well pay. It's never happened to me that I can remember, at least since the 4th grade when an aunt and uncle took me to California and brought me back, right?
Right.
Decided not to keep me. But it has called into question, are they at the beck and call of particularly, conservative or, interest corporations. And
are they
not many
making
months
their
ago,
decisions because of that versus because they're impartial justices reviewing the law?
right. I mean, that's where they overlap is, are you lacking partiality either because you're indebted financially or otherwise to someone, or are you so ideologically blinkered that you would automatically vote for or against?
Mhm.
And, Chief Justice Roberts, just several months ago, issued basically, this is a code that we've all agreed on. And this seems to be calling again into question whether, people pointed out at the time, well, you've agreed to it, but there's no enforcement
How do you
mechanism.
enforce it? Right.
Right. I mean, short of
What's the
impeachment,
penalty?
and I don't think, I, I don't think you could classify, from what we know at least, the gifts as bribery. They're probably, I mean, they influence, but there's no evidence that it was at the time they had the case before the court and
Right.
you vote this way and we're going to give you this vacation. Otherwise, you're not going to get one. But
it seems more like political donations is what it seems like. And there's how many people who criticize large political donors
right.
who are trying to curry favor. And that's what it seems like, is that but on the Supreme Court.
Yeah, I mean, it's not a good look.
Mm-mm.
And, it doesn't necessarily mean these justices are corrupt, but
right.
the key, as we know, for a judge or a justice,
it's the
is to
appearance.
avoid the very
Yes.
appearance of impropriety.
Yes.
And what's sad about this situation is this opens it up. We got critics on both sides saying, if you can't control your own house, then we need to have term limits.
Right.
Or, we need an additional, we need congressional investigations, or you can't trust them because they're just ruling that way because of, finances or whatever. But
right.
Now to be as even-handed as I can, justices do sometimes make statements. Ruth Bader Ginsburg was on the other side of the court, very liberal. She made some very tough statements when Trump was elected that, she didn't think the country could survive, those sort of things.
Right.
And to their credit, I mean, she was criticized by people on the right saying, well, how can she be unbiased? She ought to recuse herself.
Right. If she's making those statements publicly, then doesn't it seem most probable that she's making rulings on the court based on her, any type of case related to Trump or his ideology? Then wouldn't she be against that?
And actually, years before, after the 2000 election, and I don't know if it was ever confirmed, but there was some record of Justice Sandra Day O'Connor being at like a supper and they announced that, it looked like Gore might win, and it was, Gore can't possibly win, it would be a disaster.
Right, and then
So,
she went on
you
to
know, these-
decide the Bush versus Gore case.
Yeah, this is not the first time this has happened, but it's, in my judgment, it's very unfortunate for the court. If ever we need some faith that we have, and this goes back to what we said earlier.
Yeah.
If we lose our faith in the jury system, if we lose our faith in the justices,
The three branches,
then we are sort of back in state of nature, which is not a very good place to be.
and I think that is the fears. I have it strikes at the core, I think, of many of us, one way or the other, of Trump's statements of if he's not elected this fall, that democracy as we know it will be over. And the question for all of it is, do we want to essentially burn down the system as we know it or continue to improve it?
Right.
Yes, we have the Plessy versus Ferguson's. We have terrible decisions throughout our country's history. But the idea is that as Americans, we persevere and improve the system. I mean, how many times, look at gender, cases, is how much better, yet it's not perfect. African Americans, Hispanics, it's not perfect, but it's better than it was. And how much better is our legal system than another countries?
And if I can throw in one other factor,
Mhm.
this is where, we've discussed before precedents. And more than most courts, this court has overturned not so much so many as so consequential, particularly in abortion, affirmative action. There's a couple other major cases like this. And I can make a good argument for adhering to good precedents and overturning bad precedents. And so I'm, not saying we should never overturn them, but when that's combined with questions about the objectivity of judges, you have to wonder, are they just simply trying to legislate their own opinions into law, as opposed, and ironically, particularly in the abortion decision, Alito basically says, we're getting out of the business of legislating our own opinions in the law. The Constitution doesn't say anything about it, so we're not going to either. But the very fact that you're overturning a 50-year precedent suggests that this is ideological rather than, legally based. And it's, there's a difficult line to draw between law and politics.
All right. So on that, I feel almost more depressed than when we started this.
Well, okay,
that-
we're hoping to celebrate the semi-quincentennial in 2026.
Yes,
And my
2 more
hope
years
is
to
that
get
we can
there.
celebrate it without quaking as we're doing it. That it'll be
Celebrate
a
the
little like
continuation of
1976,
democracy.
where we're able to say, we got through Watergate and somehow we survived. I
Right.
hope we're going to be able to do that for 2026.
I hope so too. All right. So looking ahead, this next week, we've got Memorial Day, and then we've got a shortened version of the Trump trial. We're going to be taping on Thursday and publishing on Friday because Dr. Weil is taking a vacation. Well, and much needed vacation for him. He rarely takes them, just so everybody knows. I don't think anyone's surprised for those of you who have been listening, but he is going to take a vacation with his lovely wife. And so we're gonna tape on Thursday about the Trump trial. Most likely it will be regarding some jury instructions.
Yeah.
Most likely, of course, it will be regarding these closing statements, closing arguments. And then I think that the jury will begin deliberations this week. So we'll see where we go. We'll tape with Dr. Weil on Thursday. And the next week he's going to be gone. So you're stuck with me and Chelsea, or Chelsea and me, however is best grammatically stated.
Jesus and others and you.
There we go. I wish Jesus were talking on this show, but I think he'll have to, imply what he might be saying rather than speaking. But since he's not speaking aloud, Chelsea, for those of you who are listening to the podcast rather than watching, Chelsea's quite hysterical at the moment.
Yeah, I think the wine just hit me a little harder than usual today. Everything seems so funny.
be continuing the next week. I'm honestly hoping it doesn't conclude, because I'd love to have Dr. Vile in the conclusion of this trial.
Well, we
But
might have a verdict by Thursday night.
we might. So we're gonna see. Stay tuned with us. We're absolutely gonna stay on top of it. We can't, walk away at the conclusion. So we will have the conclusion this week or next week or the following, depending on how it goes. We will definitely have one later this week. We're going to try to do an extra one regarding Jehovah's Witnesses. And Dr. Vile's got us extremely intrigued because apparently they relate a lot to America's founding and continuation, especially legally, which I'll be fascinated.
I have a lot of thoughts on this too. It's one of my little special interests that I've researched so much about. I'm so excited.
Good. So I know nothing, so I'll just ask questions and you two can answer. This will be a lovely show. So we're gonna sprinkle that in throughout the next 2 weeks. So look forward to all three of us this coming week, at least two of us next week, with possibly a special with the three of us thrown in. And in the meantime, please do check out thelawunscripted.com. Don't forget our resources. We have the free resources through this podcast and the Law Unscripted podcast. We have the resources, the paid resources for studying for the bar, studying for your legal exams. I know the bar is more prevalent at the moment. You're just now starting, if you're a law student, the study for the bar. But if you don't know anyone, if you know somebody who's studying for the bar, check out our programs. They're supplemental programs that are cheaper. They're also, you can pick and choose what you need or what you don't, or get an entire plan. lawunscripted.com. Don't forget to like and subscribe and follow to our channels, whether it's your audio podcast or the YouTube channel, so that you can catch next week's version of our thoughts on Trump's trial or Jehovah's Witnesses or whatever comes up. And don't forget to also share our channel so others can see what we're doing, have a good time, be entertained by what we're saying. You can, agree or disagree with it, but hopefully everyone is entertained. I'm Virginia Tarani. I've been joined by Chelsea Rogers and Dr. John Vile, and we will catch you next time on the Legal Weekly One.